She went to jail for standing for her religious freedom. Welcome to Freedom Alive. In 2015, former Rowan County, Kentucky clerk Kim Davis was the first victim of the Obergefell so-called marriage opinion. Kim went to prison for 6 days for refusing to issue any marriage license while waiting for a religious accommodation. And that's just the beginning. Now Kim is asking the U.S. Supreme Court to take her case. Daniel Schmid, Liberty Counsel's Associate Vice President of Legal Affairs, joins us to discuss more about this case and what the implications could mean if the High Court takes it. I'm thankful to again be joined by our co-host, Matt Staver from Liberty Counsel. And Matt, it's been more than 10 years since the U.S. Supreme Court invented a so-called right to same-sex marriage.
Yes, and Chief Justice John Roberts, in his stinging dissent, said 5 lawyers imposed their will, not a legal judgment, and it had nothing to do with the Constitution. And they invented same-sex marriage. They invented their own understanding of marriage. They rewrote marriage that had been understood for millennia of human history. And this is what caused all of this consequence that happened to Kim Davis. She was the clerk in Rowan County, and she made a decision. She can't put her name and title on a record that affirms something that God does not bless, and that is a union between two people of the same sex under the context of marriage. And so she refused to issue any marriage licenses. And now this case is pending before the United States Supreme Court. It's a blockbuster. It could be a huge cultural change and prayerfully overrule the 2015 Obergefell so-called same-sex marriage opinion.
No question. High stakes. It's going to be an amazing program. We cannot wait to bring it to you. But our Freedom Alert, brought to you by Liberty Counsel, is next.
The Trump administration protects religious expression in the federal workplace. The U.S. Office of Personnel Management issued guidance to all federal departments and agencies outlining protections for religious expression in the workplace. The memo reads, quote, "The federal workforce should be a welcoming place for federal employees who practice a religious faith. Allowing religious discrimination in the federal workplace violates the law," close quote. Federal workers can also display religious items, engage in group prayer during non-duty hours, and discuss their religious beliefs in polite discussions with their coworkers that are not harassing in nature. Employees are also allowed to invite coworkers to religious services and can participate in other religious expressions of faith, even in positions with public interaction. The Constitution protects religious expression for all Americans, and they do not have to set their faith aside at work.
Up next, Matt's interview with Daniel Schmid.
I'm pleased to welcome to Freedom Alive my colleague and friend Daniel Schmid. Welcome to Freedom Alive, Daniel.
Thank you, Matt. Pleasure to be with you.
Daniel is Associate Vice President of Legal Affairs at Liberty Counsel and has been working with me and others on this critically important case of Kim Davis. This now is pending, Daniel, before the United States Supreme Court. But before we get there, let's go back and talk about how this case began and why this case is so significant.
Well, it began, as you know, and as your audience knows, with the tragedy that was Obergefell. Kim Davis was the clerk in Rowan County, Kentucky, and desired to exercise her religious beliefs and her religious convictions and not put her stamp of approval on a marriage license that violated her convictions. She was the first person ever in the history of the Republic to be thrown in jail for that simple request. And here we are 10 years later, still fighting her battle.
Yeah, she asked for a very simple accommodation. In Kentucky, as the clerk of Rowan County, your name, your title, authority is on this marriage certificate. And now the Supreme Court in this 5-4 opinion, which Chief Justice John Roberts said was imposed by 5 lawyers that enacted their own vision of marriage as a matter of constitutional law. The majority's decision, he said, is an act of will, not legal judgment. The right it announces, he said, has no basis in the Constitution or this court's precedent. So that decision or that opinion came down at the end of June 2015. And she asked for a simple accommodation, just to have her name removed from the license so that her name doesn't appear on it, so that she doesn't appear to be endorsing a relationship of same-sex marriage that God does not ordain or support. Very simple request, but the then governor, Democratic Governor Beshears, would not even grant that request to her.
That's right. And you will recall this well, Matt. She went to all three branches of government. She went to the legislative branch in Kentucky and said, hey, this is coming. Look at all these decisions that are coming down supporting this myth of same-sex marriage. We need an accommodation in the legislature. She had a senator introduce it, and she tried to get it that way. She went to the executive branch. She went to the governor, as you said, and said, hey, we need an accommodation here. There's many clerks that share my convictions, and we need an accommodation. And then she went to the judicial branch. We had to sue. She went everywhere she could to avoid the penalty that was imposed upon her. And no one would listen to her until the next governor came in and signed the very accommodation that she requested. She ultimately got it, but it was only after she had to be thrown in jail and suffer 10 years of litigation as a result of it before she got that very simple accommodation that the First Amendment demands, that Kentucky law demands, and that common sense should have demanded.
And the previous governor, who was in office at the time that this happened in June and July of 2015, the Democratic governor, he actually gave an exemption to his attorney general, who did not want to defend marriage as the union of one man and one woman because of his conscience. So he gave him an accommodation. But then when Kim Davis said, because of conscience, I can't affirm same-sex marriage, he said, no accommodation for you.
Yeah, that's right. And it's the same exact argument. So the attorney general said, I can't, as a matter of conscience, argue in favor of Kentucky's current law. That was his duty. You're the attorney general of the Commonwealth of Kentucky. You were required by law to defend the laws of the Commonwealth. And what they said to Kim Davis was, no, you're the clerk of Rowan County, Kentucky. You're required to do the marriage license form for the people who come in. One side of that equation said, no, we won't accommodate you. Kim Davis, no accommodation for your religious convictions. Same exact argument for the attorney general. Oh, no, that's fine. You don't have to defend him. We will pay another attorney at Commonwealth expense to go and do your job for you so you don't have to do it. Kim Davis said, we'll issue the form. I will actually do my job. I just don't want my name on it. That's all I need. Can we take my name off? Her accommodation would have cost the Commonwealth nothing, and it cost her greatly because they didn't give it to her.
And the amazing thing is that clerks at the time could be opted out for conscience reasons if they did not want to issue a hunting or fishing license, but they would not get an accommodation from that Democratic governor regarding this. And then he throws her in jail for 6 days. As you said, the first and so far the only person that has been jailed over this issue. But she went to jail for 6 days, lost her liberty for 6 days. And then while she's in the prison, another clerk, they take a marriage license, scratch her name out, issue the license. The people complained, said, no, they want Kim Davis' license. And the governor that wouldn't give the accommodation said, oh, no, that's okay. The marriage license is fine with her name scratched out. But he could have done that earlier. But by this time, he'd already refused, and she was thrown in jail. So now we get the accommodation in December of 2015 with the new governor, Republican Matt Bevins, and then the accommodation is codified in April of 2016 unanimously by the legislature. So she gets the accommodation. They already got their license. It didn't have Kim Davis's name on it. So why does the case not just end? Why are we here 10 years later?
Well, we had 3 cases. You'll remember the first plaintiffs in the Miller case said, oh, we're happy. That's all we wanted. They got their license. It didn't have Kim Davis's name on it. They went away, said, we're fine. 2 others who wanted the media spotlight, as you'll recall, and there was news articles where they were quoted saying, well, we didn't even really think about getting married at the time. It wasn't our thing. We just wanted to go down there and make a point and make Kim Davis suffer because she didn't agree with our convictions. And that's what they did. They embarked on a 10-year campaign to force damages upon her in her individual capacity, not the Commonwealth paying the tab, Kim Davis paying the tab. And they sought from her tens of thousands of dollars because they wanted to make a point. Not just that you will sign our marriage license for us, but you will pay us and we will make an example of you, which is exactly what the dissenters, you'll recall, Matt, said in Obergefell.
Yeah.
This will impose great threats to religious freedom. And these people imposed it on Kim Davis. She went to jail, and then they wanted money from her. And ultimately, they received it, and to the tune of about $300,000 that we are now fighting to get rid of.
Yeah, so in 2023, we go to a jury trial with 2 of the sets of plaintiffs. The other one you mentioned, they were fine. They didn't need any more litigation. They got the license that they needed, and they're on their own way. But the other 2 continued to come after them, and they came after Kim Davis in her personal capacity. So they strip her now of any governmental immunity protection. So it's not Kim Davis in her official capacity as the clerk. It's Kim Davis as an individual against her personally. It's a personal vendetta against her. And the 2 juries then deliberate, same evidence, same information in the same courthouse, same day. They then go back to deliberate. One comes back, says 0 verdict. The other one comes back and says $50,000 apiece for the 2 Davids, $100,000 for both of them. And then the judge tacks on attorney's fees of $260,000. So now it's $360,000 plus dollars against Kim Davis personally. Now this case with Kim Davis personally responsible for hundreds of thousands of dollars, who claimed for religious freedom and got none, is now before the Supreme Court. Why is this case so critically important? Because we're raising 2 issues, but why is it so critically important? And what can be the impact of this Kim Davis case?
Well, I think both of the issues, as you mentioned, we raised 2, and both of them are critical. The first one being, we could see, and we have requested that the court take the case on the basis that Obergefell was wrongly decided, that it's based on the legal fiction of substantive due process. What the 4 dissenters said was this was a legal myth. It was created out of whole cloth. It wasn't an act of judgment. It was political will. And we could see that overturned because of this case. We have asked the court to take it and to reverse Obergefell and do what they should have done at the beginning.
So before we get to the second one, Daniel, let's just stay a little bit on this Obergefell situation. You know, for millennia of human history, from the beginning of America and prior to America, marriage has always been understood as what we objectively know, the marriage of a man and a woman. It's a male and a female, a man and a woman. And then in 2015, Chief Justice John Roberts issues a very strong dissent, calling them 5 lawyers, not colleagues, not the majority per se, but 5 lawyers that impose their own will, not a legal judgment. It has nothing to do with the Constitution. It's a very strong dissent. And they just simply imposed on America same-sex marriage, just like they did in 1973 with abortion, with no basis in the Constitution. It's on weak footing because 3 of the justices are still there, Chief Justice John Roberts, Alito, and Thomas, that were in that original 4 dissenters. Scalia passed away. Only 2 justices are still there that were in the 5. 3 are no longer there, Kennedy, Breyer, and Ginsburg. They're gone. They're no longer on the bench. So we have a strong opportunity, I believe, and I want to encourage people to pray for this case, because the Supreme Court will make a decision this fall about whether they take it. And the issue could be to overturn Obergefell and turn marriage back to the states.
That's right. And that's, you and I think, would rightly say, Matt, that even a state doesn't have the right to redefine what God ordained from the beginning of time. It wasn't just millennia that marriage was one man and one woman. It was all time. It was from the very creation of the world. This was what marriage was. And so I would say, and I think you would agree, even the states don't have that right.
Yeah.
But what we're asking for now is the same thing that we saw a couple of years ago in the Dobbs decision, where they said, look, this is not a federal constitutional issue. Marriage is not a federal issue. It was always a state-related issue. And so what we did in Dobbs, the same thing with abortion, said, well, no, we just return it to the states where it belongs. And you'll recall in the Windsor decision, not 2 years or 3 years prior to Obergefell, the very same court said, yeah, this isn't a federal issue. You don't have, the Defense of Marriage Act can't stand because it's not a federal issue. This is a state matter. It should go back to the states. And then, of course, 3 years later, they make it up out of whole cloth in Obergefell. But that's what we're saying here. Send it back and say this isn't a federal constitutional right. There is nothing in the Constitution that textually requires every state in the Union to recognize the myth of same-sex marriage. Nothing requires that. And so the court ought to do what it did in Dobbs and say this isn't a constitutional issue at the federal level. It can go to the states and they can sort it out as they desire in the various 50 laboratories of democracy, as they're known.
I agree that there's a couple of issues like life and marriage. Those are fundamental. Those come from God. God's the creator of life. God created male and female and marriage. And states need to affirm that, strengthen it, and really have no right to redefine it and say that you can kill unborn children or that you can redefine what God's designed. But as a minimum, we're saying the Supreme Court doesn't have any business in this jurisdiction, and you need to get out of it, just like you did out of the abortion. Get out of it because you caused a mess. Now you caused another mess. And as a result of your mess, Kim Davis spent 6 days in jail, and now she faces hundreds of thousands of dollars in fines. But also what the court has done with the issue of marriage is they've come into a gender-based objective relationship that has, from time immemorial, from the beginning of time, been understood as between a man and a woman. And now they've said in that gender-based relationship, gender doesn't matter, sex doesn't matter. And what the implications of that means is that that has implications for boys and girls sports, men in private spaces of women, just deconstruction of male and female, and the whole LGBTQ nonsense with multiple pronouns that are ad nauseum. That's what it does when it says, in this case, gender doesn't matter in a gender-based or sex-based relationship. It really has an implication across the board.
Oh, it does. And where do you stop? As you mentioned, it was from the creation of time that it was man and woman. And why was that? To be fruitful and multiply. There was a rational relationship between the two. That's why God designed it that way. And then 5 lawyers, as the Chief Justice called them, said they had a better idea. I've often said in the Obergefell decision, I would not want to be Justice Kennedy on my judgment day. Because what he said is there is no rational reason. He looked at God and said, there is no rational reason for the way you designed the world. You want to talk about ego? That has astounded me forever. And you're right. The implications of that are staggering because every line past what God ordained is arbitrary. What's to stop? Because the rationale for Obergefell was gender doesn't matter. And the only reason you have to limit it to one man and one woman is animus.
Yeah.
They don't like these people. Okay, well, can't the same be said for minor marriage and multiple marriage, polygamy? Where do you stop it if you move the line from where it was at the beginning of time? And everything else becomes arbitrary. And then the implications, as you say, are staggering for everything else. Because if gender doesn't matter and biological reality doesn't matter, you're going to see a host of issues, just like what happened with Kim Davis, on religious freedom issues, on people's ability to raise their children the way they see fit in Scripture, all over the place. And just common sense things like the pronoun issue you said. If you throw out gender and throw out the basis upon which man and woman were created, it's Katie bar the door. That there are no lines left that you can defend, and you're going to end up with a whole lot more Kim Davises that are facing the threat of jail and hundreds of thousands of dollars because you didn't return it to sanity and to the origins of time.
So talk about the free exercise of religion, the issue. We're wanting the court to overturn Obergefell, which would have huge implications. And maybe we can talk about some of those implications if we have time. But then the other issue is the freedom of religion, the First Amendment protections that she should have.
That's right. And you're right, Matt, on the most staggering piece of that, particularly for men like you and I who have dedicated our lives to protecting religious freedom, and particularly in a country that was born on the will to institute a republic that protected that very freedom. To see Kim Davis in jail for that is staggering. And make no mistake, it was the result of Obergefell. It overturned decades of this, the entirety of this republic and the very foundation upon which it was founded. to throw her in jail for her religious beliefs. And so now we're asking the court, not only should you throw out Obergefell, but separate and apart from that, individuals ought to have a defense under the First Amendment that they cannot be sued for money damages just because they exercise their religious beliefs.
Yeah, and that's exactly what they asked for. So you say, well, how did they get the $50,000 judgment per plaintiff, total of $100,000? They had no out-of-pocket cost. They had no lost wages. They didn't lose their job. They did not seek any counseling or medical treatment. They had zero. So they're claiming emotional distress damages, that they should get damages, financial money damages, because of emotional distress. Again, no out-of-pocket, no treatment, no nothing. No nightmares, no nothing like that. They didn't have any counseling that they had to go to. They didn't have to lose a penny of their job. They didn't get fired. They didn't lose any income at all. It's only because of emotional stress, because they say they had hurt feelings. How ironic. They're the ones that wanted to shame her, and now they say their feelings were hurt and she needs to pay damages, and they pull $50,000 out of the thin air. And now, because of her free exercise of religion, she's being targeted to pay hundreds of thousands of dollars. The implications of that, I think, are significant, and there's some good cases, even at the United States Supreme Court, that supports the fact that she should have the First Amendment as an affirmative defense.
That's right, and your audience may remember the Westboro Baptist Church individuals who used to protest at military funerals. Now, there are a host of people, us included, who would object to some of the language that was used, directed at people who gave sacrificed their lives for our freedoms. But what the Supreme Court said is, you can't sue them because they go around in the public streets and sidewalks and espouse their religious convictions, even if you find it grossly offensive to be done at a military funeral. They didn't choose the right venue, according to a great many people. And one of those military families sued the Westboro Baptist Church in Snyder versus Phelps. Took it all the way to the Supreme Court because they said our hurt feelings, we had emotional damages because we had to witness these individuals protest our son's funeral. And the Supreme Court said it doesn't matter if you find it offensive. We protect religious freedom, and you're not entitled to sue an individual who espouses their religious convictions on an issue of public importance just because they espouse those religious views. You cannot have money damages on that basis alone. And that's what happened to Kim Davis. As you said, they had no other damages. They had hurt feelings. And they said, we're owed money for our hurt feelings. And in the Snyder case, the Supreme Court has already previously said when that's based on religious speech, you can't have it. And what we're asking the court to do now on behalf of Kim Davis is to say the free exercise clause that's right next to the free speech clause provides that very same protection.
Yeah, absolutely. And so this case really has huge implications far beyond Kim Davis. It really has implications for so many other people that have a conviction, religious-based or otherwise, regarding things such as marriage. Marriage is the union of a man and woman, or other matters regarding biological reality. If they can be sued because of their statement or because of their religious conviction, simply because their words or maybe their actions, even though they don't touch or harm anybody, but by what they do, causes someone else to have hurt feelings, then we have no constitutional protections whatsoever. That's why this case is so critically important. And I encourage people to pray for the Kim Davis case so that the justices and the clerks, as they review this case, will decide to take it up and ultimately that we have a victory in 2026.
That's right.
So, Daniel, this case went to the U.S. Supreme Court before on a different issue, not on overturning Obergefell, not on the issue of religious freedom, but on another matter, qualified immunity, which we won't have time to get into. But when it was there, and the Supreme Court was considering whether to take it along with a lot of other qualified immunity cases outside of this issue, Justices Thomas and Alito wrote that Davis was, quote, one of the first victims of this court's cavalier treatment of religion in its Obergefell decision, because it presented Davis with a, quote, choice between her religious beliefs and her job. It goes on to say about Obergefell, in their opinion, the court has created a problem that only it can fix. Until then, Obergefell will continue to have ruinous consequences for religious liberty. So I think that sets the case up pretty well, that they realize the impact, at least some of them, of their own opinion that came out in 2015. And Kim Davis is the poster child, if you will, the exhibit A of exactly what they were talking about and what they feared. Well, Daniel Schmid is the Associate Vice President of Legal Affairs for Liberty Counsel, a colleague and a friend, and is on this case of Kim Davis. It is the Kim Davis case, and it is Ermold versus Davis, or in this case now Davis versus Ermold. That's the name of the case. Continue to pray for this case. And for more information and to follow it, you can go to Liberty Counsel's website, and we've got a special page just for this case. It's lc.org/Kim. That's lc.org/Kim. Pray for this case, please, that the Supreme Court takes it, that we ultimately have great victory that impacts the nation. Pray also for Kim Davis and her family and for the entire Liberty Counsel team because of the significant threats, even death threats, that have happened as a result of just standing for God's creation of marriage as the union of a man and a woman. Daniel, thank you for joining us on Freedom Alive.
My pleasure. Thank you.
Matt, you and Daniel talked about it throughout, but really, when you consider back to June 26, 2015, and this decision comes from the Supreme Court, the confusion, the chaos that is, just the havoc that's been wreaked, it's beyond profound.
It's beyond profound what happened on June 26, 2015, when 5 lawyers, and this is the Chief Justice of the United States, using that term, not justices, but 5 lawyers imposed their own will, not a legal judgment that had nothing to do with the Constitution, and had the audacity, as Daniel said, to say that there is no rational basis for marriage as the union of a man and a woman. No rational basis. I mean, how audacious is that? Mm-hmm. How insulting is that to God, who created male and female, mothers and fathers, through whom you have procreation? There's no rational basis. Give me a break. I mean, mm-hmm. What they did was they imposed their own will, as the Chief Justice said, not a legal judgment. And as a result of that, the dissenters said, not only is this not based in the Constitution, but people of faith are going to be targeted. Well, it didn't take but a few days for Kim Davis, this was on a Friday, to be targeted when she went back to work on Monday. It's the most unscientific, most unconstitutional, most destructive decision of the Supreme Court outside of Roe versus Wade, which is the life decision.
Mm-hmm. In closing, remember Galatians 5, verse 1, which says, "It was for freedom that Christ set us free. Therefore, keep standing firm and do not be subject again to a yoke of slavery." Our freedom is a gift from our Creator. We must never forget that and always protect it. Join us here next time. You'll hear victories as well as ways you can stand up for your priceless freedom. Join us again for Freedom Alive.